that someone else does.
I have a question regarding rent control.
Go ahead.
My mom lives up on the Upper West Side. She lived in her apartment for about 62 years. And she was born in that building. She's 83 years, just turned 83 about 2-3 weeks ago. And so I recently moved back from Chicago about a year and a half ago after my dad passed to kind of take care of her and blah, blah, blah. It's not really, well, here's my question. It's like a two-tier thing. Like I said, I come back like the last year and a half to kind of take care of her and da-da-da. And under rent control laws, I'm assuming, I just want to know if I'm right or wrong, if and when my mom passes on, that apartment kind of automatically goes to me because I'm the next generation, right?
When people ask me about succession rights, sometimes they sound like they're letting me in on a dirty little family secret or something. Relatives move in with tenants all the time, and they aren't always sure where they stand. Can the landlord kick them out? When a tenant dies, often the family wonders, should we keep this a secret from the landlord? Or do we have succession rights? Can we demand that the landlord give us a lease? The first thing to do is understand the rules in advance. Sometimes it's no good to learn them later, after you've already broken them. And then you can relax, because you can make the right choices. It depends almost completely on how much you have severed your ties to the prior address.
Right.
I think that you said that you came back from Chicago to take care of your mom.
Yeah.
And do you own a house in Chicago?
No.
Oh, you've
but
been
I'm
back
registered to vote here in New York. You know, I've registered to vote here. I haven't been working. I was just taking some time out. And I was trying to deal with a little medical situation. So you know, I just have I just have a place where I send my mail, like a mailing address. But I've been back for a year and a half. You know.
That's fairly common for a sick tenant to ask their family members to move into their apartment. Now, if those family members live there for more than 2 years, then they have succession rights, which means that if the tenant moves out or dies, then the family members can remain in the apartment. But only if those relatives maintain that apartment as their primary residence. Now, if this caller maintains so much as a $5 checking account in Chicago, then he's taking a risk. If he truly moved back to New York, then he should sever all documentary ties to the former address. That means no mail in Chicago. Now, you can't have succession rights to a New York City apartment if you in fact live somewhere else. So know the rules, make sure your documents show that you live where you live, and that's the best way to stay out of housing court on a succession rights claim. Do you want to learn more about succession rights in rent-controlled and rent-stabilized apartments? Go to manhattanfirm.com/TV. If the landlord accuses you of charging your roommate or subletter more than the proportionate share of the legal rent, then you face a holdover for profiteering. The notice which kicks off a profiteering case is a notice of termination. Profiteering cases are especially deadly because there is no opportunity to cure. In profiteering cases, as long as the landlord can prove that you overcharged your roommate for even 1 month, you and the roommate could find yourselves out on the street. But there are exceptions to every rule. I just completed a lengthy trial in which the tenant in a profiteering case proved that she cured the violation when she returned the rent monies soon after the purported subtenant was to move in. If the landlord accuses you of creating noises and disturbances in your apartment that affect your neighbors, you face a holdover for nuisance. The notice in a nuisance case is a notice of termination. In nuisance cases, just like in profiteering, there is no opportunity to cure. So if you've been throwing wild parties and disturbing your neighbors, you can still be evicted even if you promise not to throw wild parties anymore. These are tough cases for landlords too, though. What makes it tough is that they have to prove that your disturbing activity is constant and repetitive and a danger to the health and safety of the other tenants. So a couple of wild parties won't do it. It has to be wild parties every week, late into the night, and your neighbors have to testify against you. So, little tip, Don't forget to invite your neighbors to all your parties. If the landlord accuses you of repeatedly not paying your rent on time, then you face a holdover for chronic rent delinquency. This is not to be confused with a run-of-the-mill non-payment proceeding. In a non-payment proceeding, the tenant can always pay the rent and avoid eviction. This is not that type of case. In a chronic rent delinquency holdover, the tenant gets no opportunity to cure. The initial notice in a chronic rent delinquency holdover is a notice of termination. In a chronic rent delinquency holdover, the judge has the power to stay your eviction for as much as a year to allow you to demonstrate that you will pay the rent on time. At the end of the year, the judge can cancel your eviction entirely. Your judge's power to prevent your eviction creates, for all practical purposes, a probation. Thus, a huge majority of chronic rent delinquency cases are settled, where a tenant agrees to a probationary period off the bat. A pet holdover can be a surprisingly difficult type of case. It starts out with a simple rule. After you harbor a pet openly and notoriously for more than 90 days, then the landlord loses the right to object to your pet. Generally, the 90-day rule is applied like this. You walk your dog every day right out the front door for 90 days, and if that's the case, then you're going to be safe from eviction. That activity is what we call open and notorious. But if you take your dog out the back door to avoid being seen by the landlord or super for 90 days, you could still face an eviction case. So the tip for tenant pet owners out there is to walk your dog. But in my last trial, the landlord tried his luck with something else entirely. The landlord claimed that my client's cats were so reclusive that they could never be considered to be open and notorious. That's because the testimony showed that whenever anybody entered the apartment, the cats were so skittish that they immediately bolted under the couch, basically. But I argued that the court should focus on the behavior of the tenant, not on the behavior of the animals. And the court found that the tenants having the food bowls and the kitty litter out in the open when the super was in the apartment constituted open and notorious harboring of the pets and allowed the cats to stay. The landlord says that his daughter is graduating college and needs another place to live, or he says that he wants extra room and he wants to combine your apartment into his. If your landlord says he wants to move into your apartment and move you out, then you are facing an owner-occupancy holdover. This is a tough type of holdover for both sides, thoroughly unpredictable. The notice that starts it off is a notice of non-renewal, which we talked about before, also known as a Golub notice. Your lawyer will investigate whether the owner meets all the technical grounds for this type of holdover, but after that, the basics are as follows. In an owner-occupancy holdover, it all boils down to the moment when the landlord takes the stand to testify that he truly plans to occupy your apartment, that he is not just planning to profit by renting it out to a high-rent tenant. Future plans are impossible to prove or disprove because anything can happen. So the landlord can easily be lying about what he plans to do and nobody would know. It's up to the judge to eyeball the landlord on the stand and make a gut decision as to whether the judge believes it or not. If you are over 62 or disabled, then the cost of the landlord doing an owner-occupancy holdover goes up. He cannot evict you unless he provides you with comparable accommodations elsewhere. Now, what is comparable? Well, you don't even have to go there. The courts will ensure that before they boot out a senior tenant, that apartment will be as good, if not better than where you live right now. Okay, so we just went over the major kinds of holdovers. Let's go over a few issues that are common to all holdovers.